Welcome, I'm Don Resnikoff, and I'm welcoming you on behalf of the DCBar Consumer Rights Coalition, and also the DCBar's sections that are co-sponsoring this event. Our principal speaker today is Kathleen Konopka, and we're very honored and pleased to have her here. She is a senior advisor to DC Attorney General Karl Racine, and until that recent promotion was Deputy Attorney General for that office, focusing on antitrust. And also with us is John Gracia, who will, as chair of the DCBar's Consumer and Antitrust Committee, and he will offer some questions at the end. In addition, attendees can type in questions, and we'll be able to deal with those. Now, I'm going to start, Kathleen, by asking you to share with us your professional experiences that led you to focus on antitrust. I know you have 24 years of experience in investigation and litigation, but I think it'll be more illuminating if you tell about it than if I do.
Thanks, Don, and it's really great to be here. I actually fell into antitrust. So I started my career as a federal prosecutor at the U.S. Attorney's Office here in DC, and subsequently moved over to DOJ's Office of the Inspector General, where I did large-scale reviews of various federal programs. But after a number of years with the federal government, when I decided I wanted to try private, I prioritized going to a firm where I felt comfortable, I knew the people and liked the culture, and they needed antitrust folks. So I knew almost nothing about antitrust when I started, but I grew my practice and knowledge litigating large class actions on behalf of plaintiff classes of both direct and indirect purchasers at Cohen-Milstein. After 5 years with that firm, I wanted to go back to the government, but I loved antitrust and learned that I really wanted to stay in that field. And so I went to the antitrust division of DOJ and was there for about 5 years. After a couple of different stints in consumer protection and with the New York AG, I have landed in my current position with the DC AG, where I've continued my antitrust work.
That's quite an interesting background. And we're going to focus today on the antitrust work of the DC AG's office, and more broadly about the role of state-level antitrust enforcement. And to begin, can you describe the role of the DC AG with regard to affirmative cases generally and antitrust in particular?
Yes. So when Karl Racine became the first elected Attorney General, soon after he took that office, he instituted really the first great push for affirmative litigation that office had seen in erecting the Public Advocacy Division. And that is the division until recently that I headed, and it houses all of the DC AG's affirmative civil enforcement work in furtherance of the public interest. That actually includes 10 different subject matters, everything from consumer protection to housing enforcement, environmental, workers' rights, nonprofit, civil rights, and of course, antitrust. PAD is currently about 80 people strong, with about 65 attorneys and 15 support professionals, and we engage in an active antitrust practice through that division that's both local and national.
And I understand that the DC Office of Attorney General often coordinates with states and the federal government on its antitrust matters. And I'd ask you to talk about that coordination, and particularly focusing on the role of NAG, the National Association of Attorneys General, and also the new US DOJ Liaison Office, which I understand is headed by a former colleague of mine when I was with DC, Sarah Oxenham Allen.
Yeah. Absolutely. So, as I'm sure I don't have to tell probably anyone listening today, antitrust is extremely labor and resource intensive. And so it's very difficult for many states, particularly the smaller ones like DC, to investigate and litigate these matters independently. And therefore, we often find it helpful or even essential to partner with our sister states and or with our federal partners, the FTC or DOJ. NAG, or the National Association of Attorneys General, is an excellent vehicle for both information and resource sharing among the states. The association provides important trainings and tools, and also provides funding sources for us to continue our investigative and litigation work. And it also provides forums for states to discuss and collaborate on multi-state matters that have national impact. As to the DOJ liaison office that you mentioned, I can't say enough good things about DOJ's decision to demonstrate a great commitment to federal and state collaboration by bulking up their liaison office and bringing in former Virginia AG Sarah Allen. She has been an incredible force for greater cooperation between DOJ and the states. For example, just very recently, she supported state involvement in the ongoing American Airlines JetBlue trial that's going on as we speak in Boston. And there was a role at trial for the states in that case. And she also assisted me personally in facilitating DOJ's filing of a statement of interest in support of DOJ's local antitrust case against Amazon.
Yes, I recall her as a force to be reckoned with.
She remains that.
Okay. But now I'm going to turn to particular cases. And I'm going to start you with national cases where you've partnered with the federal enforcers and other states. And you just mentioned American Airlines JetBlue. And you might as well go on and explain about that. That's a coordination story between the two companies and so forth. But why don't you explain about that?
Yeah, so this is actually extremely timely because this is a trial that's ongoing in Boston as we speak. The case challenges a joint venture between American Airlines and JetBlue, which the states and DOJ contend is really tantamount to a merger. The agreement provides that these formerly fierce competitors coordinate both on routes and revenue share for flights into and out of New York and Boston airports. And this agreement has a huge potential impact on DC travelers, given the number of flights that connect DC to those sister cities. This case is being prosecuted in Boston, as I mentioned, by DOJ and a small group of states, including DC. And really significantly in this matter, it's been a real partnership and collaboration between DOJ and the states, where the lead state, Massachusetts, has actually had a significant speaking role in the trial, both participating in witness examination and also in the opening, which has really been a great move forward in collaboration between DOJ and the states.
That's great. I want to take you back to an earlier set of cases, the 2017 drug manufacturers cases. And my reason for doing that is that those are an example of price fixing cases, generally considered sort of a more garden variety category. And so I'd like you to tell us a little bit about those cases as a vehicle for describing what DCAG can do on that sort of case.
Sure. So, I'll say the generic drugs collection of cases, because there's actually 3 complaints at this point that the states are involved in. And this was actually a matter that was overall handled criminally by DOJ, but is being litigated civilly by a large number of states and also private plaintiffs. And as I mentioned, the states have now collaborated and joined on 3 complaints, which raise price fixing allegations against a number of companies and across a very broad swath of generic drugs. And I think, one key thing about this particular matter is it really is a very key example of why state collaboration is so important. It's ongoing, but this set of cases has already been hugely labor and resource intensive. It really has taken the full might and muscle of the collective state force in order to litigate these cases, just because there's so many defendants, so many drugs, just so many, kind of thorny issues that have become a part of this effort. And so certainly the ability to work across states and offices have been essential to this prosecution that has now been ongoing, as you mentioned, for about 5 years.
Okay, that's interesting. Thank you. I'm going to move you next to Google, which is, from my point of view, it seems a little complicated because there's an extent to which DC has coordinated with states in the DOJ, US DOJ, and there are situations where DC has proceeded independently. And so that's quite an interesting set of circumstances, if you can explain that.
Sure. So as you mentioned, Google is a repeat defendant for us. We have challenged Google's restrictive contracting and other exclusionary behavior in collective actions with a large number of other states and DOJ under the antitrust laws. But we have also sued Google under our local consumer protection laws in our local superior court. And that particular case deals with misrepresentations and omissions and unfairness claims under the consumer protection laws in relation to their tracking of geolocation data of its users. Several other states brought similar matters to what DC brought in their own local courts in a coordinated effort earlier this year. And I think this kind of highlights a distinction that has historically been maintained between our antitrust practice and our consumer practice. In our antitrust practice, prior to Amazon, we typically challenged antitrust violations in federal court under federal law, and typically collectively, either with our federal partners or sister states, or very often both. Conversely, our consumer practice, even though we have very often collaborated and coordinated with our sister states and often federal partners in terms of consumer protection matters and concerns, especially when we're dealing with national and global companies, those matters are typically brought under our local consumer protection law in our local court, as is typically done with other states. And in part, that is because our local statute, our Consumer Protection Procedures Act here in DC, is an extremely robust, broad statute. It gives us a great ability to protect our residents and consumers. And we typically find that we're able to get the greatest relief from bringing those matters locally in our local court under local law.
So share with us what happened with the local Google case, the consumer. What happened?
So we are still very much in the middle of it. As I indicated, we just filed that earlier this year. There was a small group of additional states that filed on the same day. I think it was 3 or 4 other states filed on the same day in their local courts. It was those cases came out of a coordinated multi-state investigation into misrepresentations and omissions that were made by Google in conjunction with their collection of geolocation data. And we're very much in the middle of that case. We have recently prevailed against a motion to dismiss that Google filed, and we are in discovery. But we're very early on in that case, and we expect that would go on for a considerable period after today.
Now, you mentioned about Amazon and how that was an example where DC did go ahead and use the local courts. And I know it didn't work out perfectly, but could you tell us something about that?
Sure. So, I think that a great emphasis and want for the Attorney General, and also for myself in leading this charge, was really to work toward building up the local jurisprudence. All of our statutes, so antitrust is kind of the last one to be brought in, but all of our local statutes, from our local consumer protection law, our local nonprofit law, even a number of our environmental laws, don't have a lot of jurisprudence here locally, because DC had not been really a large affirmative force prior to Carl Racine taking office. And so one thing that we've really been trying to do is build up our local jurisprudence, bring cases in our local court, and really develop that law in terms of going forward. And antitrust and Amazon was kind of the latest move in that progression where, we started investigating Amazon. We had a great interest in bringing this case because particularly during the pandemic where so many folks were so dependent on being able to get delivery of essential materials to their homes, we really saw that these violations had a great impact on DC residents and obviously nationally as well. We were very interested in bringing this case, and we decided we wanted to bring it in Superior Court under our local antitrust act, which is the first time the DCAG has used that act in the court. We wanted to do it to really move forward the jurisprudence in the local court and really to establish the local court as an appropriate venue for antitrust enforcement. As you mentioned, the dismissal highlighted that we have some work to do there. The local court in DC at least has evidenced a lack of understanding of antitrust and also a lack of willingness to dig in and fully and fairly evaluate these complex claims and questions. I'll note that the DC Superior Court initially dismissed the Amazon case orally without requesting argument and without a plan to issue a written decision when this was the first antitrust case brought by a government enforcer in that court. And indeed, the oral dismissal did not even consider all of the district's claims and allegations, but dismissed the entire case outright. That case is now on appeal. We did file an appeal, and we just got a briefing schedule. And so that is going to be moving forward, and we are confident that that decision will be reversed. I do think, however, that we should not be discouraged in terms of using our local court and acts in the future. I think it's a really important venue and tool and really something that we should lean in to in the future. But I also think that we should use Amazon as a teaching moment to consider the needs of our local courts and jurists, and really the need to educate the bench in regard to this type of issue and these types of claims. And I definitely think that's a job that the DCAG and the DCBar can really collaborate on in the future.
I think sort of an interesting aspect of that is that, as I understand it, the DC antitrust statutes closely modeled on the federal. They're very similar. Mm-hmm. Where other states like New York, for example, that's not the case. They're much different. And I think even California is different. So California, I understand, brought a case very much like the one that was dismissed in DC. Mm-hmm. And so it's going to have perhaps the same struggle that DC has had, working with a statute that's not necessarily as amenable to success. So,
yeah, I mean, I think the benefit that California has in bringing their similar case against Amazon that they just brought recently is that unlike the DC Antitrust Act, which really doesn't have a body of jurisprudence behind it in the local court, the Cartwright Act does. And so, California and folks in California have been bringing cases in the local courts there and cases under the local antitrust laws for a significant period of time. And so there really is a body of law that has built up there that I think gives kind of a foundation and support for California that DC was lacking. And I think that's part of the interest in DC and other states in really trying to build that foundation the way California has.
Shouldn't it be helpful to DC though that the local judges in interpreting the local law, since the local law is very much like the federal law, should be influenced by the federal jurisprudence, you would think?
Yeah, they absolutely should be. And certainly, if you read the briefs in our local Amazon case, almost all of the citations on both sides, both by us and by Amazon, are in a federal cases because, of course, we just didn't have anything in local courts here. So certainly there should have been a greater influence of the federal law on the local court here. I just think there was a lack of kind of digging in and understanding about it.
Yeah, well, that makes sense. Well, I'm going to take you to the Facebook case for the reason that it seems to be another example where back in 2018, DC took actions which were unique. And I think the press noted it too, that the actions, this had to do with Facebook and Cambridge Analytica, where the press noticed that actions had been taken in Europe, but in the United States, not so much, and that DC actually broke ground when it brought its case. So I wonder if you'd tell us a little bit about that one.
Sure. So our case against Facebook in 2018 was another case like the Google geolocation tracking case that we brought this year, was another case being brought under our CPPA, our Consumer Protection Procedures Act. So it was brought under our consumer protection laws. And it challenged the misrepresentations and omissions that Facebook made to consumers as to its privacy policies and protections, which led to the Cambridge Analytica crisis. And we were, in fact, the first mover among state enforcers to bring that case because we thought it was important to send a message that such violations of consumer rights would not be tolerated. Again, like Google, Facebook's a repeat defendant for us. So, you know, in addition to bringing our 2018 consumer protection matter, we've since brought an antitrust case in federal court against Facebook. And for that, we partnered with the FTC and almost every single state in the nation. And we brought that case to challenge what we've called Facebook's buy or bury strategy, namely the company's policy and practice of either acquiring or excluding their nascent and potential competitors in order to maintain their market power. That case was dismissed in DC District Court as to the states on laches grounds because of the age of some of those mergers and acquisitions, and was recently argued on appeal in the DC Circuit. The New York Attorney General has been leading that case, and in fact, their Solicitor General argued the case in the DC Circuit, and we are awaiting that decision.
Thank you. I think in discussing these cases, I think people in the audience present and for future viewers will see that the states really are forced to be contended with, and kudos to DC for the initiatives that it's taken. I'm going to move next to some of the positions DC has taken on issues of policy, and particularly on areas involving labor antitrust, non-competes, and labor antitrust and the federal merger guidelines. I know that DC has been a voice on those topics, and I wonder if you could tell us something about those.
Yeah, these are really issues near and dear to our hearts, and we've really worked hard in DC to position ourselves as leaders on these issues. DC led 2 comments to the FTC on non-competes and restrictive covenants in employment contracts, and really the importance of greater enforcement in that space, because those issues really resonate in terms of the harm that they can pose to workers. You know, when we think for a moment about the pricing impacts that antitrust violations can have for consumer products, the price of something you want or you need going up, when you think about what you actually earn for a living going down, you know, you can think for a moment about kind of the resonant greater importance that that means to you, as opposed to, you know, the incremental price increase of consumer products. And so we really, especially for low-wage workers, are talking about just an incredible impact when antitrust violations occur in labor markets. And so DC has worked very hard to work with federal partners on that. We've also worked locally. So the DC Attorney General's office advocated and advised the DC Council on our non-compete ban. We are only one of 8 states that have one currently, and that went into effect just earlier this month. And so that particular statute, greatly limits the type of restrictive non-compete and other types of restrictive covenants that can occur in employment contracts here in the district. So that's something that we're very proud of. We also recently co-led a comment to DOJ and FTC on the merger guidelines. So our federal partners are working on their overhaul of the merger guidelines, and the states weighed in. There was a general state comment that was very fulsome that DC also joined in terms of more general comments on the merger guidelines, but DC co-led a supplemental comment because we really felt there were some important issues missing from that general comment, specifically the importance of considering effects in labor markets and points of equity in merger analysis. And so some of the things that we advocated for in that comment was both to consider moving the idea of labor reductions to the opposite side of the balance sheet in merger analysis. Folks often told us when I was at DOJ that reduction in labor force was an efficiency. We never bought it, but now the idea is really that that could be a harm as opposed to an efficiency in a merger analysis. The fact that you are suppressing the ability to compete in labor markets and wages as part of a merger. And also considering notions of equity, the idea of considering smaller submarkets and the impact that mergers can have on those submarkets. For instance, rural seniors who are unable to drive and are unable to get to different product availability, and really how that may be shaped in terms of the availability of products and price increases for some really important submarkets that have really important ramifications for equity issues.
Thank you. Now we have a question from Ann Wilcox, which she's typed in, which I'm going to work in at this time, and I'll just read what she wrote. Can you address environmental litigation that DC may be involved in, PFAS chemicals, et cetera, and semicolon, and are there efforts by defendants to keep such agreements private?
So we have a number of environmental litigations going on right now. We most recently filed a case against Velsicol, which was the only manufacturer of chlordane. And chlordane is a toxic chemical that actually still exists, even though it's been banned for years and years in the Anacostia and other waterways of the district, and have greatly impacted the fish and other types of aspects of the water. And so we did bring that case recently. That case is public. I'm not sure in terms of the question whether, I'm not sure if I kind of understand how DC is implicated in the question.
Well, I guess maybe a rephrasing would be, to the extent there are dangerous elements to that chemical, is there any element of the evidence that's come in that would be of interest to consumers, which is getting attention, getting hidden from consumers?
Yeah, so certainly our complaint is public and fulsome in terms of both the chemical and also the impacts that it has had on the waterways and other aspects of the District of Columbia. As far as I'm aware of, there has been some discussion recently about the need for more public disclosure about environmental harms. It seems like most of that would come from a question of if there are private settlements that maintain confidentiality of those settlements or information. DC does not do confidential settlements, in part because, well, not even in part, because we are a government enforcer. What we do is public, and everything would be subject to FOIA laws anyway, and so we don't engage in confidential settlement.
So to clarify, here's a follow-up from Ann: are you taking legal action against PFAS?
So at this point, we have not filed anything in terms of manufacturers of PFAS or other types of dischargers of PFAS. It is something that we have been investigating, as has been made public by the fact that we engaged outside counsel in that matter, and we publicize all of our outside counsel engagements.
Thank you. As we get to the end of my questions, I'm going to give you an opportunity to share your views on the importance of state antitrust laws.
Yeah, I mean, I think we've already talked about this a fair amount, Don. Just the fact that obviously, you know, we would hope, and I certainly think it is the case right now, that our federal partners have been extremely robust as of late in their enforcement. They've indicated a great commitment to it, and we've seen some, you know, robust moves toward investigation and litigation by both the FTC and DOJ. I don't think that's always the case. I think it depends on the administration. It depends on the time. And states can really provide a very strong partnership and backstop to that when there is, you know, less robust prosecution at the federal level. And even when there is, states have a really significant role to play there. And so certainly, you know, I've seen some great moves that we've already talked about with both DOJ and FTC, and really creating a greater commitment to collaboration with the states. The states have been working very closely with our federal partners. And so we definitely want to continue that vein. But I think there also is a great role for states to play in really bulking up the local jurisprudence of antitrust laws. I think California is way ahead of most of the game on that, but I think, you know, all of us need to play our part on that, and that's really been DC's move in bringing Amazon. It's certainly something that we hope to do. We have a number of investigations percolating now, particularly considering the new non-compete ban and our interest in labor markets. And so, you know, we are hoping to continue to use our local courts, and we're hoping to also continue to educate our local court and develop the jurisprudence there.
Thanks a lot. Before closing, I want to turn to our steering committee chair, John and Gracia, for any closing comments or questions you may have.
Thanks, Don, and thanks, Kathleen. I don't have any specific comments, but I do have a couple of questions, if I might. And you know, one sort of at the federal level where we've been talking, and then I'd like to have one just on more local concerns, if we could. Yeah, and you explained, you know, really nicely the significant role, you know, that DC has played in a lot of the issues and cases of national concern. And really even spearheaded, you know, some of those and several of those. We've seen, or at least at the federal level recently, what we might call sort of, you know, string of losses, both at the FTC and the DOJ. And, you know, I wondered if you have a view that you can or you're willing to share on some of those cases. Do we see the agencies coming out very aggressively in some of their speeches and positions? And as that plays out in the courts and we don't see wins, has the agency overstepped, or have the agencies overstepped? And I guess just to add to that, because we've seen that, you know, not in merger, in labor, in price fixing, sort of across the board, right?
So I think an important thing to note about, you know, kind of bringing these cases generally is that when we decide to take aggressive positions at either at the state level or at the federal level, part of that aggressive position means that we can't be afraid to lose. We also can't be afraid to lose if we're going to develop jurisprudence. If you're working toward developing jurisprudence, working toward reasonable expansions of the law, you know, you need to be able to kind of work in the vein that you're going to be willing to lose to kind of create that advancement and development. And so certainly I think that there's been huge steps forward in terms of a willingness to take on hard cases at both the federal and state levels. And I think that's largely what is being seen now as we kind of move into these new realms. I also think that, there's been a great move, in Congress and elsewhere to really think through whether the current antitrust laws work for the current economies and current markets. And I do think, certainly in some respects, and maybe in many respects, the antitrust jurisprudence has not kept pace with the developing economies and the developing industries and markets that we're seeing. And so it's very hard to fit something like Google into an industrial market definition. And so I certainly think as we move forward and we think about the types of cases that we need to be bringing in the digital market space, in the healthcare space, in a number of these spaces that don't look like widgets, we need to really think about, how we're going to craft those, and the idea that it may take crafting it more than once before the courts are able to be educated and understanding and kind of be able to see that analog in a way that creates a good result.
Yeah, I guess it takes some time, to move the courts, maybe more than it might to move, policy at the agency. Thank you. For my other question was on sort of more local concerns, to the extent there's anything that you can share there. I understand, the importance of the cases, that you've talked about, and how they have, both national and local implications. Are there matters of more local concern that you can talk about, where maybe only DC consumers, or regional, maybe, DC, Maryland, Virginia, more regional cases, that might be of interest?
Yeah, so we don't comment on pending investigations typically, but I certainly will put in a plug that we want to hear from consumers, to the extent that folks do feel that there are problems that need to be addressed, or complaints in regard to either the consumer protection space or the antitrust space. We're really interested in hearing about that. We obviously are very interested in considering enforcement of our new non-compete ban and how we will formulate that. And so we're very interested in kind of hearing what is out there. We have conducted a survey pretty recently with our partners in Maryland and Virginia on non-competes in the industry, in various industries, and kind of how often they seem to be implicated and imposed. And so I do think that there's fertile ground for us to really identify some targets and think about how to fast move forward in that space.
And we did see some of that, I guess, during the pandemic, if not in antitrust proper, at least with respect to price fixing. There was the gasoline case and maybe a couple of others.
Yeah, so the CPG case was actually brought under the price gouging statute, and that case is still ongoing. We've filed summary judgment and we're awaiting a verdict.
Yeah.
Well, I think this has been excellent. I think, Kathleen, we thank you for helping people understand really how important state antitrust enforcement is and how important the role of DC AG has been in antitrust enforcement. So again, thank you very much. And with that, we'll end this session.
Thank you, Don. It's been great.
Thanks, Kathleen. Thanks, Don.